We're delighted to be here this morning to start what I hope to be will be a very engaging conversation on this exceedingly important issue of capacity building. What I want to start with the panel is the fact that we have all come here with an assumption, I think, that domestic courts charged with investigating and prosecuting war crimes have now demonstrated, at least in many people's minds, a fair degree of success, and that the growth of the capacity of domestic war crimes courts to undertake these prosecutions should be seen as an important legacy for the ICTY. But it was not always that case. There had been reports as early as 2004 that there was real concern about whether Serbia, for instance, and Croatia could undertake these types of trials in a fair way. There was even reports, most recently as last year, suggesting that, well, the ICTY's impact on the development of the prosecutions in Serbia was actually quite small, that the ICTY's role really was quite limited in that. But the assumption that these courts that have come into being in the former Yugoslavia could be seen as an important, even the first or second most important legacy for the ICTY is an assumption that's being made. I think it's being made with this conference, it's being made in discussions. And I want to ask the panel in its first question whether or not all of you would agree that at the end of this process we can look back and say that the ICTY's legacy, and one of the most important legacies, is simply the fact that there exists now in the region these domestic war crimes courts, whether successful or not, that they exist. And is that one of the most important legacies? Would you agree? If you agree, raise your hand if you would agree with that assumption on that. Everyone. Any caveat on that?
Well, I think the situation is different from country to country in this regard. I don't think there's a special war crime court in Croatia, for instance, that has been established. So I think the legacy has to adapt to the reality on the ground that we will find in different countries. I think this is something quite obvious.
But regardless of the modality that's being used in each of the countries, would we say that the fact that there's a process that places at its foundation the principle that those that have been accused of committing these types of heinous crimes should be brought to justice, regardless of the modality? Would we say then that's a legacy?
That's for sure, yeah, that I agree fully.
Other thoughts?
Well, I would say there is no doubt about that, although with a caveat that it's not only because of that legacy that there has been a growth of domestic courts to deal with war crimes and crimes against humanity. There are a number of other factors. I think the analysis that puts accent also on a number of other factors is relevant. I mean, it is correct. Probably the existence of the tribunal and the work of the tribunal, like ours, has certainly given an input to that, a great input, but I wouldn't say that it's only due to the tribunal, but certainly it's an important part of the legacy of the tribunal.
Shelley, you've written a little bit on Kosovo. We've not heard a lot about Kosovo, but if I were to ask your question, the same question within the context of Kosovo, and whether or not you feel that that too will become a real legacy for the ICTY, what would your thoughts be on that?
Yeah, I think it's a different situation. I very much agree that you have to take every part of the former Yugoslavia and analyze it, and what the impact of the ICTY has been. I think coming from part of the legacy is what we have learned over the course of the last 17 years about operationalizing an international tribunal of this nature, as well as building the capacity in country for nationals to be able to prosecute these crimes. And I think in part we've learned that that's where we should start. And I think that's part of the legacy of our engagement in the region of the former Yugoslavia, is that we all agree to some extent now in the international community when it comes to supporting the rule of law that the starting point should be a national view of how to strengthen national capacity to address these crimes, and how international tools can help and support national agendas. But I think very much over the course of the 17 years, that's where we've gotten, is to understand that the starting place really is national strategies, national assessments of their own needs, their own desire to develop, strengthen the rule of law, and to operationalize transitional justice mechanisms in a way that they own and lead that process.
This whole issue yesterday came out of national ownership, if you will, and we're going to talk more about that later on. Georgia, you had some thoughts?
Sure, thank you. I have to say, obviously, that there is a significant causal relationship between the ICTY and domestic prosecutions. And we wouldn't have the capacity that we have today without ICTY. There's no doubt about it. And I mean, I don't think we need to go into that. I think this is also very significant for ICTY legacy, specifically because of the specific challenges that we had in the history of the ICTY. I mean, given that it was not located in a region, no procedures were there. We also heard that actors, to a large extent, until very recently, were not from the region for all sorts of different set of circumstances, you know, and the outreach started pretty late. It was never founded from the core funds, so there was some lack of commitment to put more into ICTY outreach. And finally, probably the archive is unlikely to be ending there in its original form. So in this respect, I think the effort that's been put in since the last, let's say, 5 years on the part of the ICTY to make sure that, and incentives, in fact, put in, I think were very significant for where we are today.
Well, let's move on then, because we're talking about agreeing the importance with some caveats on the existence of these courts or modalities in whatever way we want to identify them. And now we need to move on then to the idea of support in the sense of the legacy of support. Judge Moloto, you've talked about this and you've indicated that we, the international community, the UN, perhaps the ICTY itself, have a responsibility to provide the resources, including the human resources, towards the continuation of this capacity building in Yugoslavia. So I think we have to now ask ourselves, to what extent should the ICTY be responsible for this type of capacity building that we've been talking about, and particularly within these national systems? Does it make sense that the ICTY not act as the driver, but perhaps just someone that can motivate others to act? Shelley, you've talked a little bit about in the past about the UN and the fact that the ICTY simply doesn't have the financial resources. Vincent, you talked about the EU and about the role of the EU in providing this type of financial support. So I'm curious from the panel, exactly what should the ICT be doing in the future in providing the type of financial support, the human resources support for this ongoing capacity building? Judge Moloto, you want to start with that?
Thank you. Well,
should pull that mic a bit closer to you.
Good. Obviously, from the point of view of financial resources, there is very little that the ICTY can give because it is itself an organ of the UN and it is maintained by the UN. But what I was saying is that the international community can make a contribution both financially and by way of providing human resources to help the domestic jurisdictions to continue with the work that they've been doing. A case in point is, for instance, Bosnia-Herzegovina, where we've been having some international judges there helping the judges, the local judges. And it's well known what an outcry what we had at the end of 2009 when Bosnia and Herzegovina government wanted to stop the international judges carrying on the job there. Obviously, this working together and mutual transfer of skills is very important, but it cannot go on unless there are funds, unless there are people out there who are prepared to come in and it can be made possible for them to come in. The tribunal is coming to an end, and I guess a whole lot of human resource is here within the tribunal which could be deployed in some of these countries at the end of the tribunal to help. But then the international community must come to play to facilitate that move of people to the domestic jurisdictions.
Okay. The EU focus on this, what's the role?
For us, I think the situation is pretty simple. I think there are two elements. The first element is the full cooperation with ICTY, which is a clear conditionality for accession to the European Union for any country of the region that wants to join. But the second part, it's the same coin in a sense. The second facet of the same coin is domestically prosecution of war crimes as well, and we cannot dissociate the one from the other. Now, to tackle the second one, I think ICTY has to be part of the process, but it's certainly not the sole actor into this process. There are a number of other actors present. There is the OEC, there is the European Union, who is going to be the leverage, let's say political leverage, maybe to achieve certain result. But what we need is that all these actors are able to do, I think, three things. First of all, is to have clear understanding of what are the problems with domestic prosecution of war crimes, defense of witnesses, in absentia cases, whatever. You have a long list of issues that can be addressed in the different countries. Secondly, I think there is a need to have a strong dialogue and ownership and willingness on the side of the national authorities and national judicial authorities to deal with this issue. And third thing, I think we need to reinforce and think about the long term, which is reinforcing the civil society role, because it's civil society that has to play the role of pushing all these actors to continue to work in the same direction. Also, when ICTY will be phased out, when the OECD stuff will be phased out as well, and when the European Union will be phased out as well of these countries, because the problems will remain and will continue to be addressed.
You know, Judge Pokar, did you want to say something? And then I want to follow up on what you just said, because you've said an interesting point on this civil society issue. Go ahead.
I would like to make perhaps a comment on this, on the question. There are things that the tribunal can do and things that the tribunal cannot do. That's clear. It's clear that as a matter of giving resources, the tribunal is not the best institution to act, because it does not have resources to give to other institutions. But I would like to say something on the concept of capacity building, actually. What does capacity building mean? Is bringing about the ability, the skill of the judges there to do their job. I don't think that's entirely correct. I mean, going to the region, I had contacts with judges there in all the countries in the region, and the level of the judges, of many judges,